Really pleased to be here today. As some of you know, I'm Mariam Faruqi, a lawyer and South Asia Regional Director at iProbono. Really pleased to welcome you to today's lecture, which is on a particularly fraught subject in our region, penalizing marital rape in South Asia. And I think it's wonderful to see that we have participants from 5 different countries across the region joining us today. Before I hand over to our moderator, Gitanjali Prasad, iProbono's advocacy lead, who brings to this conversation many years of legal research and social work experience. She spent 6 years at the Center for Equity Studies in Delhi before joining us. And I'm so pleased that she'll be able to take this conversation forward with our fantastic speakers. And I wanted to personally thank our speakers for joining us today, particularly our keynote speaker, Justice Sapana Malla Pradhan, who Gitanjali will introduce in more detail, but really Justice Malla is joining us from Kathmandu today at a particularly tenuous time where she's sort of in the midst of an important constitutional case which could potentially change Nepal's parliamentary history, and we're very grateful to her for giving her time. But as she noted before she joined this lecture, this particular issue and women's rights in Nepal and across the region are things that she's been adjudicating on and discussing and fighting for over a decade. So it's really fantastic to have her experience here with us today. She's a stalwart in our region for women's rights, really. I'm also so pleased to welcome Dr. Naomi from who's in Dhaka at the moment. She's a friend of iProbono's and will be speaking on a subject that I know is very close to her heart as well. Again, Gitanjali will provide a more detailed intro. And of course, Saroop Ijaz, who's joining us from Lahore, a long-time supporter and friend of iProbono's. He's a criminal lawyer with a fascinating practice, and I'm really looking forward to him sharing some of his experience on this issue in the region. Before I hand over to Gitanjali, I just wanted to tell you all a little bit about this series on decolonizing the law and why we're talking about decolonizing the law in South Asia. So hopefully what we're hoping is that each lecture in this discussion section of South Asia socio-cultural crystallization within and around an inherited colonial, criminal, and civil penal system. And of course, Nepal is very different. So it's great that Justice Malla will be able to give us the Nepali context. And we'll really be talking about this post-colonial influence in our region. What does it mean to us today? And how do we move ahead as we continue to legislate and make decisions in the context of this colonial heritage in many, in many different jurisdictions? So I'm really looking forward to seeing a lot of you throughout the course of this year to continue some of these discussions. And it would be fantastic if after the lecture, you share some feedback with us. I know that there's going to be a detailed question and answer session, which Gitanjali will be moderating. Any thoughts you have on what we can do and what we can talk about during this these decolonizing the law discussions would be fantastic as well. So again, a big thank you to our speakers for joining us, and over to you, Gitanjali.
Thank you so much, Mariam, for introducing today's discussion. It's great to see all of you here from across the jurisdictions we work in, and a pleasure to moderate the session. For those of you not familiar with our work, iProbono's mission is to enable people to access their rights in pursuit of a just society. As part of our South Asia program, we lead crucial cross-border exchanges and adopt a regional approach to human rights advocacy, strategic litigation, and legal capacity building. This ties into our area of discussion for today. About 2 years ago, ED of UN Women said that the home is one of the most dangerous places for women across the globe, where research at the time showed that only 4 in 10 countries criminalize marital rape. As most of you would have seen from the background note, there is high incidence of marital rape and abuse within marriage across South Asian geographies. While majority religions and ethnicities may differ, we're largely homogenous as societies in terms of the forms that patriarchy takes and the widespread impunity that pervades despite some legal frameworks in place to combat violence against women. With the exception of Nepal, the remaining jurisdictions have inherited colonial era laws. I'd like to move swiftly to introduce our esteemed speakers who we are very lucky to have with us Justice Sapana Pradhan Malla is a judge of the Supreme Court of Nepal since August 2016 and a former member of the Nepalese Constituent Assembly. She's a former president of the Forum for Women, Law and Development. In 2008, she was a joint winner of the Gruber Prize for Women's Rights. Justice Malla has a master's in comparative law from the University of Delhi. She also completed a mid-career master's from the Harvard Kennedy School of Government. She was a member of the Committee Against Torture from 2014 to 17. We're very grateful to have you here, Justice Malla. Our next speaker, Saroop Ijaz, is a lawyer and human rights activist based in Lahore, Pakistan. He is the Pakistan representative of Human Rights Watch since 2014, serving as senior counsel for the Asia division, and is also a member of the Human Rights Commission of Pakistan. He was the former chairperson of the Lahore High Court Committee on International Human Rights. He's a writer and columnist and has published articles in the Los Angeles Times, The Guardian, Open Democracy, Jurist, and Dawn, among others. Thanks so much for being here, Saroop. Our final speaker for today is Dr. Sharin Shajahan Naomi, who is Assistant Professor of Gender Studies at Asian University of Women in Dhaka, Bangladesh. She completed a PhD at Murdoch University in Australia. In the past, she's worked for nonprofits, including the Research and Evaluation Division of BRAC, Empowerment of Law Through Common People, Manusha Jonno Foundation, and I Know Salish Kendro in Bangladesh, as well as the Center for Human Rights Education at Curtin University in Australia. Many thanks for being here, Naomi. Justice Malla is going to begin with a keynote address, followed by Saroop and Naomi's contributions on the contours of legal positions on marital rape from their respective jurisdictions, after which our speakers will have the opportunity of asking each other questions and reflecting on the presentations. I'd encourage everyone in the audience to please type in questions you may have into the chat box and send them directly to my colleague Meenakshi Menon, who is Senior Program Manager for South Asia at iProbono. We will most likely be able to take a couple of audience questions before closing out the session. We'll begin now with Nepal, where marital rape has been criminalized, but discriminatory sentencing exists for marital rape versus other forms of rape. Justice Malla, thank you again, and over to you.
Thank you, Gitanjali, and very nice to see you all discussing a topic which is very close to my heart as well, and critical issues in the region, especially in recognizing women's autonomy, women's self-determination, women's dignity, women's privacy. The country who had colonized many of our country has shifted her paradigm on position of marital rape, whereas many of the country which were colonized is still continuing the heritage. Being part of marital law reform process in Nepal, I'm going to share my own experience in engaging in the whole reform process, through which I will explain what is the law, how it came, what are the challenges we are facing with. So for this, now that time I was in the bar, now in the bench, so I also had a different position, but I want to take you back to 21, 22 years back. We were sitting in the office. A 59 years old woman came to our office and she said, I have been raped by my husband every day since marriage. And her children, a banker, a doctor also came and they sought justice for her mother. We were helpless because law was barrier. At that time, we were providing legal aid to one of the community hospital in Kirtipur near Kathmandu. And then there we got a case where a victim of violence reported after 7 days of her delivery, her husband wanted to have sex, and on denial, he forced and tore the stitches. And then that hospital was particularly providing counseling and healthcare services to the victim of violence. 9% cases were per year on victim of marital rape that came to the hospital. We failed to assist them for the justice because in every case law was a barrier. So that pushed for us to challenge the law. Because the then law said rape means raping others' wife. And instead of using the word woman, the law says raping others' wife. And the assumption was that raping your own wife is exempted from being offense. So you may think, wow, Nepal was never colonized, but how come this colonial law existed? Of course, being neighbor country and the drafter being influenced by colonial law when the Nepali law was codified, and also religious law. We had contradictory sanction that is reflected in behavior as well as in the law, and that contradiction where one hand husband were to act as their wife's disciplinary, and other hand the husbands were also their protector, and woman considered property of husband. Woman's duty is not only to tolerate domestic violence but also condone it. So that concept existed, and when we challenged the law in the Supreme Court, nobody expected, nobody took it seriously, nobody thought we will get a positive judgment from the court. But in 2002, when the judgment came from the Supreme Court says rape is no rape. Rape is a grave nature of violence. No matter who is rapist, they cannot get exempted from the punishment. And even because you have a relation with the accused, and even if he is husband, they cannot get exempted from the punishment. So the in the interpretation in this judgment, the judges said that law itself has regarded consent as a basis of marital relationship. And marriage cannot be solemnized in the absence of the consent. In similar ways, mutual consent is compulsorily required to have sexual intercourse between husband and wife after marriage as well. So court also directed, there are some complication also in the judgment, which I will not go into detail, but in this case, the court also directed in providing immediate relief, whether they want to get divorce or they want to take partition, and higher degree of punishment in case of rape to the child marriage, and issued a government to bring the law to address the gap, to have a appropriate solution in this regard. Next day, the news of the ruling had made sensational press coverage. First day, all the newspaper, sex without consent of wife is a crime. All the newspaper were covered. And from next day, I mean, I still have some of the clippings which I wanted to show, but I could not because of the time. Data, I mean, if you look at those newspaper, like all media's mocking cartoons, snide jokes, derisions, there was the most of difficult, I mean, for us, that was the most difficult case forever. Cartoons, men running, wife trying to catch to have sex, men asking first sign consent paper, some husband hiding newspaper so that wife does not know if it's a crime. And we were also personally attacked, criticized in this case, being against the culture, being against religion, being against marriage institution. And in even like formal event, people communicated women like us should be shot. And then not only that did not affect much to us, but they said women like us even to be brutally raped. We realized one does not even have to be raped physically. By even saying they can affect on your dignity, in your privacy, and they can emotionally rape. So right after the decision came in the court, some Martin Chowdhury, they wanted me to come and share how we were successful in this case. I was a little uncomfortable because I was myself going through a lot of stress, but then I decided to open up, and that was that breaking barriers, talking openly on the challenges I was going through was quite helpful. So sometimes you also need to break the silence of a kind of challenges you have been going through. So one hand, yes, we were quite excited. We were very happy because we had a decision from the court. Court recognized marital rape as a crime. But then we realized, yes, that is not the end, because this is just a beginning, because you have to make sure that law is enacted, law is enforced. Recognition through the court itself is not enough. But then even in this difficult time, it's not that you get criticized only from the men, because the criticism is from the patriarchy who wants to control the sexuality of women. Even women said, oh, this is not your priority issue, because we have many other priority issues. It's only one woman or two women who are victim. So why we want to change the law and shift the whole paradigm of marriage institution, because we should have a different priority. We said, no, even if one woman is affected, we cannot say that it's her issue, because it's her rights, human rights issue. It's her right to say no. It's a issue even related to non-discrimination and equality. And even during the pleading, like when the case was in the court, we said no, because if you look at the Article 1 of the CEDAW, because it's a non-discrimination not only based on sex, caste, culture, but it also says non-discrimination based on the marital status. And we had brought that argument, and that argument was quite seriously taken by the court, and even mentioned in the judgment. And then by then there was also another case, like where the court had, like, there was a law that says, like, if you rape a prostitute woman, only 500 rupees fine or 1 month's imprisonment. That was also passed by the Supreme Court with some reason which I will mention. But then after having this judgment, the law was amended in 2006. The judgment came out in 2002. In 2006, law was amended. And this law, of course, included, said, like, intercourse by any person without consent of woman, means it included any woman. And it also provided punishment, but the punishment was like 3 months to 6 months imprisonment. 3 months to 6 months imprisonment. So one hand, it was recognized as a crime, but punishment was so little. But even having this little punishment, immediately upon enactment of the law, 2 women from different parts of Nepal, and not like ordinary women. One had a tea shop, another had a tobacco shop. They went for the justice. But what happened in one of the cases, the husband was released on bail, and that created further threat on her life. So we contacted them immediately when we came to know about this case. And then we asked if they want to challenge the law which had just come out, because it is a variable which is again creating more threat, making them more vulnerable, and discriminating on the punishment. So they agreed. Then again we went to the court. And when we went to the court, when we went to the court said, in this case, the court said, no, it's the discrimination on punishment. Although the government attorneys argued that no, because you are having a same law for different categories of person. Because if you rape unmarried woman, you have a different punishment. If you rape, there's different punishments. So they fall under different category. So it's not a discrimination. So that was their argument, but the court says no, it's against the principle of it's against contrary to the constitutional principle. It's contrary to the fundamental right, and also inconsistent with the principle of criminology, because it's tend to encourage an individual to commit an offense. That was the same argument which was used even when the prostitution lesser punishment raping prostitute was coerced, because state-made law itself is instigating to use that provision and get exempted from the punishment. So the court further says you cannot discriminate punishment between marital and non-marital rape, because this cannot be a justifiable reason in providing just because they are of different categories, because rape is a severe nature of crime and it has to be the same punishment. Yes, we were excited, but when you work in this kind of issue, you are not only challenging the law, you are also challenging the state, you are challenging the culture, you are challenging the religion, you are challenging the patriarchy. We try to engage continuously. We try to bring a common voices in this regard. Law changed then, now it has already been changed twice, because now we have a complete shift of paradigm of law in Nepal. We had Mulkian, now we have a separate criminal code and civil code. Now it's up to 5 years imprisonment, and they have also divided, because in the case of marital life, it's a 5 years imprisonment, but it says only when you are in a marriage relation. If divorce case has been filed, if you have taken property, or if you are living separately, in case if those situation a woman is raped, then you have a same punishment. So still there is some problem, but the beautiful side of law is that now we have an Anti-Domestic Violence Act. You get all the protection extended under the Domestic Violence Act to the victim of marital rape, as well as you have a right to divorce, or you have a right to get party. So all those provisions are there in the law. I also want to mention here, when the law was debated in the parliament, major resistance was came with the religious argument. Because Nepal, somehow even now we declare as a secular state, there's a deep-rooted Hinduism in our heart, and then they says, oh, in religion and tradition, consent, once you marry, consent is not required. That argument came, but beautifully in one of the decision, and the judges have said that in Hindu religion and its literature, stress on purity, cleanness, and behavior of good faith in the conjugal life. It cannot be said that Hindu religion and traditions exempts the heinous acts of rape to wife. Sexual intercourse in the conjugal life is a normal course of behavior, which must be based on consent. No religion may ever take it as a lawful, because the aim of good religion is not to hate or cause harm to anyone. So that was the argument. So what we did in that time is some of the reason that was given in the judgment itself was used in our advocacy. So if you want to go through the judgments, we already have those 2 judgments translated in English. I can share with you. And before I wanted to talk to you, I also wanted to get data of marital rape. Although we have a data of rape, number of cases reported, number of judgment that has come, but unfortunately we do not have segregated data of marital rape. So that is where we see even now the gap, which I will keep in mind, and I will ask my court to start, to have a disaggregated data. But again, yes, we have a now law, we have an improved law, because even now the sentences are based, different sentences are determined based on the age, based on the aggravated forms of violence. But still what we have been facing a challenge is how to empower women. How to empower women. Many people are not aware of the law, even if they are aware about the law, if they have no choices in the life. When I'm talking about choices, because empowerment also includes social empowerment, and not only legal empowerment, social empowerment and economic empowerment. Sometimes you cannot exercise the choices. So how to create those choices so that women can exercise the choices? People have an option in their life. And the chain of law agency has to be educated. They have to be sensitized, including mindset that still expect women to be submissive, to compromise for children, compromise for the marriage institution. How can a woman be forced to live in a violence relation? We really need to question this. with option, with the choices, empowering the whole process, creating enabling environment. But I still remember when the first verdict came from the court, some women who have been victim of marital rape, they said, my husband, our husbands have stopped raping these days. Some of women, they came and they said their husband started pleasing them in the bed once that judgment has come, and now when law has come. Some women, many women, they came even with some, like thank.
I think we may have briefly lost
Sorry.
Justice Malla. No problem. No problem.
My last point is so they started pleasing, though these numbers are small, but we are very hopeful things will change. Now we have a law. Law is an indicator of change. Law is also initiator of change. Law is also interpreter of change. When we have a law, you can create accountability. Thank you for making me part of today's discussion.
Thank you so much, Justice Malla, for this very personal narration of what creating a shift like this looks like. And we really look forward to hearing more from you during the discussion later on. We're going to move now to Pakistan, where Saroop will walk us through the evolution of the law on marital rape, the interplay of the penal code with Islamization, and the reasons for the lack of enforcement of the existing law. Thank you.
Thank you. I'm very glad to be here. And because given the theme of today's discussion, one of the themes is colonial law. And in Pakistan, like Nepal, is an exception in the sense that it was not colonized in the way that the rest of South Asia was. Pakistan is perhaps an exception for 1947, where there were conflicting strands now, or multiple strands, perhaps not always conflicting, strands of influence on lawmaking, which is Pakistan did inherit a colonial British law, both in penal laws and civil laws. And then in the late 70s, starting from the late 70s, 79, there was an attempt to Islamize the law. And how that, I'll speak briefly about how that is played out. So Pakistan inherited the IPC, which is section 375, which talked about rape, which created an exception. Which exception is, I mean, it very briefly for the audience, is that it has to be without consent, without approval, or consent by under duress, with someone not your wife, that somebody you're not legally married to. And so that was an exception that was created. So marital rape quite specifically was excluded. So it was not so much as a failure to not criminalize marital rape. It was a deliberate legislative attempt coming from, essentially from, at that point, Victorian England understanding of both conjugal relations, as they were called, and sexual autonomy. In 1979, Pakistan passed a series of laws, which were called the Hadood Ordinance. And what that did, it created a special set of laws dealing with crimes against women. It dealt with other things as well, but based on religion or understanding of religion. In case of Pakistan, religion was Islam. Pakistan is an overwhelmingly Islamic country, Muslim majority country. And perhaps the striking thing there was that it had a conception where the distinction between sexual intercourse is essentially at one level, it's just there's permissible sexual intercourse and there's non-permissible sexual intercourse. And the permissible one was under marriage, and all other sexual intercourse is criminalized. It was criminalized in Pakistan and remains so. So, and that led to all sorts of very egregious. It also, for the HUD offenses, which I can talk about in detail if somebody wants me to, it was a special set of evidentiary requirements. So you had to have 4 male pious witnesses to the incident. It also shifted the onus on all cases of rape, proving rape on the woman. One horrific example from that era was in 1985. It's the Safia Bibi case where a blind woman was raped. And she went to court and she was charged with fornication because they said, while you could not prove rape, what you've admitted to is sexual intercourse outside of marriage. And so there was this larger context of the law treating marital rape, all rape, and marital rape in particular, in a very sort of misogynist, patriarchal way. After a sort of very long struggle of the women's rights movement in Pakistan, in 2006, there was a major breakthrough. The law was amended. I mean, there's a series of laws which were amended, including the Hudud Ordinance, but also Section 375, and which is the law which defines the offense of rape. And Section 376 of the Pakistan Penal Code gives the punishment for rape. And that exception was removed. So rape was now defined by sexual intercourse without approval, without consent, and the part about legally married or not was taken out. So in that sense, Pakistan very specifically, because it was a very specific amendment to the law, has made marital rape an offense. And it is, unlike Nepal, it is an offense at par with all other kinds of rape. So in that sense, it was the progressive step. And while it remains a progressive step, Pakistan has not had any cases of marital rape reported so far. And we will talk about, there are multiple reasons, both religious, sociological, institutional, for that, which some of them plague, all of them plague the larger landscape of barriers to access to justice for women, and they are just exacerbated, they're just amplified in the case of marital rape. But one colonial concept that was indigenized in Pakistan and then in other jurisdictions, my understanding as well, which is a civil law concept, is also has an interplay with it, and which is restitution of conjugal rights. So when the British came to India, they brought with them a religious concept, which was the restitution of conjugal rights, which is based on the idea that both parties to a marital agreement, to a marriage, have responsibilities to each other which they can demand. And what it means is a woman can demand maintenance from a husband. And when the law initially came, it led to, in some ways, a whole host of Indian women going to courts and for using this as an instrument to demand at least maintenance, demand basic necessities. But how it is played out, at least in Pakistan, which I can speak out with greater confidence, is the Pakistani courts interpreted it to mean that husband can demand for restitution of conjugal rights and what the law said was, if a husband or wife without a reasonable excuse withdraws from the society of the other. And that was read into in both restitution of conjugal rights. So there was law, subsequently in the Muslim family law ordinance was passed, and it was read as a larger part of the right to privacy. And what that meant was, as long as husband complies with what his part of the bargain is, or was viewed to be his part of the bargain, which is to provide maintenance, essentially take care of the basic necessities of the wife. He has the right to cohabit with the wife. And while it does not specifically talk about sexual intercourse, it does in certain cases. But the assumption was that consent is a blanket consent. So when you consent to cohabit, it is then between the marital affair. And again, this is the same in the Islamic law as Pakistani courts have interpreted it of marriage, which is unlike certain other jurisdictions, let's say, as opposed to the Catholic law, was that it is the marriage is not a sacred contract; it's a civil contract, and how it was read was that once a consent is given, once a consent to the contract is given, so that's the only time where consent is a factor, where it is the offer and acceptance of the contract. And once you've agreed to enter into the contract, then it was read with the conjugal rights. Then you have a right to demand certain things from the husband as a woman. There's is which is called dawa, which is certain amount of payment. If it's agreed in the contract, you can demand residence. You can demand, I mean, whatever the husband's means are, you can demand that he spends or reasonably takes care of you. And your part of the bargain, while it remained unspecified, was that you are supposed to fulfill the woman's set of conjugal duties. And that is where you had an indigenization or even an Islamization of the restitution of conjugal rights, which was a civil concept, which remains a civil concept, which is that, if the husband and wife are living separately, one can go and say, that I demand that the other party fulfills their rights to the marriage contract. And what that has led to essentially is, even with the exception that there is in the law, there are no cases of marital rape which have gone to either the High Court or the Supreme Court. There are cases that have had a component of marital rape. So it is there's Section 377, which is sexual intercourse against the way of nature, and then there's the larger head of cruelty. So cruelty in marriage is something that a wife can use either as a grounds for divorce. Historically, now, I mean, Pakistani law does not require any grounds for divorce apart from the party's opinion. But initially, traditionally, what it was that you had cruelty as a breach of a contract or the terms of the marital agreement. So you do have some cases of cruelty which have a marital rape aspect to it. But it's also, so that's the legal situation, which is, as I said, it is some colonial concepts along with Islamization, the dictatorship of Ziaul Haq from 1979 to 1988, and a convergence of the two. So you have right to privacy and restitution of conjugal rights. You have the Islamic concept of marriage, of nikah as it's called, which talks about consent, but it only talks about consent, or as the interpretation given by the Pakistani courts only talks about consent at the time of the marriage. So no marriage can be contracted without consent. But once after that, it talks about rights and obligations, and the obligation on the husband, as I've told you, and the obligation of the wife. Sometimes it's spelled out explicitly. Sometimes it's said is in sort of in euphemism, but it is to cohabit with the husband, etc., etc. So that's one legal part of the problem. So while the law has been made, the legal part of the problem remains that the courts, and they've not been called upon to adjudicate this. So the Supreme Court and the High Courts have not laid down the law on it, partially, because they were not required to. So that's one level, the principal level of where it plays out. But there is another level, which is that it's all very, very difficult for a woman to have a criminal case of marital rape to be registered in Pakistan. And that is because of, as I said, because of patriarchy, because of misogyny, because of just the dysfunction of the criminal justice system and the entire criminal justice space being hostile to women, starting from the police station to prosecution to the courts. I mean, it gives me great pleasure to be on this panel with Justice Malla. I'll give you an example. Pakistan remains the only country in South Asia who has not had a woman judge to the Supreme Court. Pakistan has, in all its years, never had a woman judge to the Supreme Court. I mean, we hope that would change soon, but let's see. So part of the problem also is a practical problem, or at the level of enforcement, where there's similarities with what Justice Malla was saying about Nepal, that there is not awareness of this law. There is confusion on if it would be religiously okay to go to the court and say that the husband is raped. And then the third practical problem is that there won't be a case registered. As I said, even if there is a case registered, so even if you pass all of these barriers, so you pass the familial, societal, your perception of religion barrier, go to a hostile space like a police station in Pakistan for a woman, speak about something which is considered deeply private and have a case registered. The courts have interpreted it to be in the head of in the head of privacy. So Pakistan does not have a right to privacy in the Constitution. Pakistan has Article 14 of the Constitution, which talks about dignity of person, etc. But it talks about the inviolability of the house, or the privacy of the house, the invasion of the house. And that manifests itself also in both civil and criminal laws, which is again based on, I mean, it has been Islamized, but it's based on Victorian English principles of each man's house is his castle. And that sort of also, in a larger context, influences both eminent domain laws, but also familial laws. So the threshold for cruelty, so there is cruelty, there is maintenance, and there is the restitution of conjugal rights. So that's essentially the legal landscape for this. And there are other sort of problematic parts of evidential questions. The Evidence Act, which is inherited, it's Evidence Act 1872. It's a British law. Pakistan Islamized in 1984, but essentially the law remains the same. It just has, the nomenclature or the language or the idiom has been Islamized. And that presents problems, so while you have substantive law which criminalizes, but up to the point that you take sort of certain evidentiary protections, it is very, very difficult. So while it might be, as Justice Malla said, there could be a separate category for people who are separated, or where it can be demonstrated that they had filed for divorce, they were living in separate dwellings. But often that's not how it plays out. Often it is they're living, the marriage is intact legally. And there, to have in a place like Pakistan, or in most jurisdictions, but as I said, it's amplified because multiple reasons that I've spoken about, that it would be, even if a court was willing, the gathering of evidence, given the limitations of it. So the Pakistani courts very recently have started taking in DNA as primary evidence for rape cases. Just to give sort of example of how deep-rooted the problems are. 4 days ago, in a province in Khyber Pakhtunkhwa, in a province of Pakistan, one government proposal was that alleged rape victims, so people who are alleging rape, should have to pay what in Pakistani terms would be significant money for their own medical examination. So that disincentivizes people who are victims. So essentially, in that sense, there is a problem of religious interpretation and colonial law, and there's a problem of enforcement. So since 2006, it's been 15 years, and there is no case, at least no case of note. I stand to be corrected if there are exceptions, I don't think there are, particularly at the cases which have reached superior judiciary, where marital rape is a stand-alone or is the principal assise principal question of the proceedings, and nobody has been convicted of marital rape. So marital rape at best is viewed as cruelty, and so it is being cruel to your wife as opposed to a distinct criminal offense. And being cruel to your wife was not a criminal offense. Being cruel to your wife is grounds for dissolution of marriage. So, and that is where you see sort of, both civil and criminal laws getting converging, where it is not viewed because, and that comes with the idea that this, because it happens in the privacy of the family or within the ambit of a marital relation, you don't have separate consent on each instance, or consent is a blanket agreement. And so, I mean, I can go on about this, but I mean, essentially, this is my apologies if this was sort of too legalistic, but this is the background or the context in which marital rape is viewed in Pakistan, and in my opinion, partially explains why, despite the landmark legal change of 2006, has not translated into great practical impact. And I'll be happy to sort of be part of the conversation later on. But thank you for now.
Thanks so much, Saroop. That was so interesting. And I think the nuance and the legalities sort of indicates steps forward, steps back in sort of dynamic shifts that keep happening. And we'll definitely come back during the discussion. Thank you very much. Naomi, last but not least, Naomi is going to be explaining to us the complexity of the laws on marital rape in Bangladesh, where marital rape is actually criminalized. And she'll be commenting on people's working knowledge of concepts like consent and women's sexuality and how that's shaped. Thanks so much, Naomi. Over to you.
Thank you so much. Thanks for inviting me. So I completely agreed with Justice Sapnaji and Saroop that the contradiction that we have inherited from the, penal code is extremely, complex. And Bangladesh, although it has modified its laws, but in some respects, especially the laws that are particularly for women and that are related to the private lives of women, that have always met lots of resistance in the ways of reformation. So one of these areas is definitely marital rape. And we could see that although we have a new law, which is Women and Children Repression Prevention Act, and that act has also gone several changes, but when it comes to marital rape, there is no change at all. So there is a law, 1860 Penal Code, which tells that, which legitimizes, marital rape to some extent, saying that if your wife is above 13 years old and you are having intercourse with your wife, this is not a rape. And then we have the punishment section, which is telling that if your wife is below 13 years old or below 12, then it might be rape. But in that case, maybe your punishment is only 2 years. I think it's something 2 years or something, not like the punishment like the rapist. Then again, it comes to the consent issue, and we see that if a girl is unmarried, then for her, the age limit is different for understanding whether she gave consent or not. And for the girl who is married, for her, that is different. So for the girl who is unmarried, and if there is a sexual intercourse and she is below 14, definitely it is a rape. But if she is married and she is above 13, then it is not a rape just because she is married. So when those contradictions were there, people used to tell that, okay, we shouldn't be bothered that much because we have Child Marriage Restraint Act, and government is very much committed for, restraining child marriage, and Bangladesh has a success story of reducing child marriage. Now, to add a further layer of complexity, the new Child Marriage Restraint Act 2017, it has added a exemption clause which tells that, marriage before 18 years can be legalized with the permission of the court for the best interest of the minor, with the permission of the parents. So by doing so, we have further justified marital rape for a child, especially for female child who are more vulnerable. So those issues were not much talked about until we had a case, and that case was Nurun Nahar case that you have mentioned, and that sparked a huge concern in the country that someone died because of vaginal bleeding. So that means we have to do something for marital rape. Before that, although some women activists came forward, there was extreme level of backlash to talk about all these things, and people just didn't want to accept that consent could exist. They used to think that consent means, it is irrevocable. So a wife has given a consent for sexual intercourse until the marriage exists. So before this case happened, there was a huge backlash against marital rape, and no one was, feeling comfortable to talk about it. After this case, now we have a High Court petition which tells that why this exception clause shouldn't be declared illegal. So now there is a much debate and conversation and dialogue that how we can actually make marital rape illegal. So on that note, I would like to add as well, we have another act, Domestic Violence Prevention and Protection Act, and in that act also the section sexual violence, that also doesn't include a very explicit term called intercourse. It includes a term like any act of sexual abuse, but it doesn't tell explicitly rape or intercourse. But so far I know the cases that are brought under domestic violence, definitely the act of sexual abuse includes forceful intercourse. So in that way, marital rape is being addressed when it becomes a domestic violence, but it is not formally there. So if this word could be inserted in Domestic Violence Prevention and Protection Act, I think we could start talking about this crime in the legal paradigm. In terms of social and cultural paradigm, there is absolutely silence about this sort of forceful intercourse. The line between coercion and consent is extremely, extremely thin, and normally we don't talk about it. This issue of consent actually further came into the forefront when we had another case where a girl died out of brutal intercourse, and there was allegation that the person with whom she had the intercourse was her boyfriend. So there was a discussion that whether boyfriend can rape a girlfriend. So this type of discussion actually remind us that we construct the category of consent in a very shallow way, and we mean that a boyfriend can rape a girlfriend, it is a sexual intercourse, it is not rape. Husband can have a intercourse with wife, it is not a rape. So we have plenty of orthodox interpretation of religion, which tell that it is the duty of the wife to please the husband. So if we have this type of orthodox interpretations of law, it is very difficult to, talk about the issue of consent. When the issue of religion is invoked, the reason become very, very, fickle. So as Saroop has said that, the Islamization, the orthodox, part of Islamization, the way it has been promoted against gender equality, that we also find in Bangladesh nowadays, the rise of radicalization, the rise of orthodox interpretation of religion, at the same time, the rise of radical feminist plea for talking about consent and women's sexuality. Recently, we had a big movement against rape, and in this movement, there were two divisions. One was centering around Shahbag, another was centering around National Parliament. The one that was centering around National Parliament, that was run by the feminist group, and they were very courageous to talk about consent for the first time, that, let's talk about consent and how we construct the category of consent. And that is very, very important. Because before that, no one actually thought that we should talk about consent. So it seems that everything will be a crime if it has some form of violence, if there is a bleeding, if there is a death. unless that we shouldn't talk about it. What happened in the name of marital rape that was practiced for ages in our culture? Like we know that, in our family, with our friends, whenever there is a marriage, the next day, women feels difficulty in walking, women feels vomiting, women feel sick, and we normalize it, by our laughter, by telling that it happens, and we keep on pushing women to satisfy her husband. The domain of sexuality, freedom of choice and desire becomes the exclusive domain of men. So women presence in this domain is just to complement man desire and to be a passive recipient of man desire. And that has been legalized, normalized, naturalized by media, by TV, in our society, in our culture, and further indulged by the orthodox interpretation of the religion. So that's how marital rape is being very much normalized in our society, unless there is a death, there is a severe injury, something like that. Otherwise, it is considered to be a quite normal thing. So central to these issues is also women's sexuality and women's desire. That is, a subject of taboo and silence in our culture. And we have seen that the penalty for talking about women's sexuality is huge, that whenever any women dare to talk about women's sexuality and, her freedom of choice, her right to say no to her intimate partner, that issue has faced severe backlash. And this anti-feminist backlash is getting extremely powerful with the rise of feminist demand for more and more rights. So in this note, we have to understand that these issues are quite internuanced, like law, society, culture, and religion. So, and it is very difficult to make awareness on marital rape just through law without addressing the deeper cause of this type of thinking, that women as a sexual being is just an object, or her duty is to please the husband and nothing else. And if we can't take off the social pressure on women to please her husband, to please her boyfriend, then we will keep on justifying, a rape in a different form, and we will not accept that this is a rape. So apart from law, of course, there is a strong advocacy in going on to reform law, and probably it will be, reformed at some point of time through court intervention or through government intervention. But what about those women who feel extreme pressure to satisfy her husband in this domain of sexuality and desire, which is completely controlled by the patriarchal structure and the patriarchal thoughts? Because there is no awareness program which talk about it. There is no awareness program which talk about how to, have a intercourse with a virgin women. They talk about to protect virgin women. They talk about to take consent from women. But how painful it is to have the first intercourse for a virgin women, no one talk about it. So we talk about consent, we talk about, sexual education for the people. But can we have a education system to teach our boys that how to approach a woman who is a virgin? So that's why if we can't actually address this deepest misogynist thinking, and we cannot claim or reclaim the domain of sexuality for the well-being of women, it is very difficult to actually stop marital rape at some point. Probably by use of law, we could actually stop the violence to a great extent, and that is a great success. But the social way of coercing women will be very difficult to stop unless we create a huge level of awareness or reclaim the domain of sexuality on behalf of women. So these are the social issues. So if I'm again switching back to the public health issue, which tells that the adolescent fertility rate, which is 31% still, like 15 to 19 years old of adolescent women are becoming pregnant every year, and the rate is 31%, which tells that that some form of rape, if we have a very ideal definition of rape, that okay, a sexual intercourse with a woman before 18 years old should be considered to be rape. Either she has given consent or have not given consent. So if we see the adolescent fertility rate, we can understand that how much pressure women have to go through to become pregnant, even if her body is not ready, and to satisfy her husband. So these are the legal, cultural, and religion part of Bangladesh. So I think I'm looking forward to some questions and everything, which will help me to clarify more.
Thank you so much, Naomi. We're going to transition quickly. We have about 25 minutes left. We wanted to open it up to you, to Justice Malla, and to Saroop to ask each other questions and have a conversation. And in the event that you'd like to transition to audience questions, we can do that shortly thereafter. So over to the three of you. And if not, we have a few questions for all of you. So just let me know.
So why don't you ask us?
Great. Okay. So we'll start with a question that's come in from a listener in India who is commenting on how Indian parliamentarians have had a fairly standard response to sort of movement to have a law that penalizes marital rape. And they claim that socioeconomic and cultural variables like literacy, economic status, and acceptance of religion, diktats, should be considered. And they say that India is not ready as a society to penalize marital rape. So it would be very interesting to hear what the three of you would have to say in response to that argument.
I mean, do you have an order in mind, or you should tell us, citizen?
Just go ahead, Saroop, if you'd like to start.
No. I mean, I guess, it's not an India-specific objection. Or it's not even a marital rape-specific objection. So I'd sort of, this is to say that a society is not ready. As I said, and particularly given the theme that is of this conversation or this series of conversation with colonialism. So societies do change, sometimes organically, sometimes through external shocks. And the idea that, any set of rights, because this is an idea this is taken, which is used in Pakistan for, civil and political rights, the entire, and it can be applied to anything. If anything, then the argument should be a society which needs, or which has women who are in Pakistan, India, or Bangladesh, who are worse off in gender parity indexes or any sort of social economic indicators. The argument might sort of just be reverse, that they need it more, and they need it more urgently, and they need it more explicitly. And hence I was saying not only in substantive law, but in evidentiary law, because what they need is, after the law is formed, which is the first step, and one hopes that that happens in other places as well. But the Pakistani experience is that alone is not enough. So they need sort of, in a hostile state structure. So I think if that argument could actually essentially mean that there is a greater urgency for this, and that there is a greater breadth of effort that is required. Other than that, I mean, I didn't see the force of the argument other than that.
Thank you, Saroop. Justice Malla?
No, I think I would also add on what Saroop ji has mentioned, because society is diverse and culture is not static. And you want to have a law which is contemporary. When we say diverse, and then I would also like to bring our own example, because when law was enacted, even though it was up to 6 months imprisonment, 2 ordinary women, uneducated, just had a small tea shop or tobacco shop, they were using the law. So in that context, I don't know how much we should agree with the argument, because India is such a huge and diverse country, and therefore, like, it's very difficult to agree with the argument. which has been put forward. And nextly, because everyone thinks, oh, because it even in India, like cruelty, it has been recognized as a cruelty, and even in Pakistan, Saroopji mentioned that divorce, you can a ground for the divorce, dissolution of marriage. But one hand, cruelty is one form of torture, and other hand, you are just giving option to dissolve the marriage, nothing else. So how do we see one hand, like we all agree in case of rape, demarcation is consensual or non-consensual. I'm not talking about the statutory rape or other forms of rape, but when consent is a demarcation, and what I liked in our case, the judges said that even in marriage, consent is must. Even in marriage, consent is must. And then how can we agree now with that notion which Saroopji also mentioned, that once you give the consent is forever, and even for sex or intercourse. So I think that consent things to be reminded. Force is force. Force is a form of violence.
Right. Thank you. Naomi, would you like to add
So
anything?
that reminds me something that I think it was in last year, one of our parliamentarians said that women should, wear modest dress, and that created lots of backlash. I do believe that when it comes to India, they have much more widening civic space, in a sense that people can actually speak out no matter what the government thinks or what the opposition party speaks. So different type of forces and groups have lots of power to speak up and come up with their voice, which many countries do not have. So I think even if there is a resistance from the Orthodox group, and no matter government is a ally with the Orthodox group, the resistance is very powerful and possesses lots of power to push through much more liberal and radical ideas. The example is a female Hindu priest, which is unimaginable in a country like Bangladesh. Even if we take the example of Hindu women, the result is women equal share in the property, which is unimaginable in Bangladesh. So I think this issue, to me, it's not a matter of concern in a space where lots of voices can actually blossom and come up with their ideas, and resistance, counter-resistance, backlash. At the same time, groups against this backlash are very much visible.
Right. Thank you so much, Naomi. Saroop, there's a specific question for you, which is around what you think, as someone deeply embedded in the criminal justice system, what you think the state should be doing to encourage women to come forward to access justice on this offense.
Right. I think there's a whole host of things. This is, the canvas is very broad, just given the scale of the problem, how deep the problem is. As I said, if one tries to think about it linearly, the first step would, of course, to be for marital rape in particular, is to create the substantive offense and to create it unambiguously. The second, as I mentioned earlier, is it has to be followed with procedural or evidentiary amendments, which make it, and which becomes a challenge in criminal justice systems which are dysfunctional for all cases, and they are pre-modern, and they are testimony-based criminal justice system, which rely on sort of testimonies and prosecution witnesses and defense witnesses in sort of ocular account, as Pakistani and Indian Supreme Courts say. So that means it has to be a modernized version of the criminal justice system. But the second, so those are sort of the law points. The third is to make, as I said earlier, to make the criminal justice system less hostile or more inclusive, depending on how one frames it, generally, which would require a whole host of things, which would require having more women at police stations and in the prosecution, in the adjudication. It would mean having the men who are there to be more sensitized to this. It would also be tying into the first question, which is this argument that the society isn't ready. So the floor of the society, actually, I really do think in most of these cases, the society is ready. If by definition of society, we mean the victims, they are not, they just don't know that they have this available to them. And that requires an outreach attempt, which is not only that this is the law available, but the confidence that the state or the government is both willing and able to protect people who decide to pursue this line of reasoning. I mean, and of course there is, but another major chunk of what would be perhaps, and that might one can talk about in detail at some other point, is what I mentioned is there's the criminal set of laws when you talk about marital rape, but often this interplays or this with the civil law, the family laws. So how we define marriage, how we define the contract of marriage, how do we legally define the rights and obligation on spouses. So for this particular offense, as opposed to other offenses, this offense would require not only a clinical forensic criminal law amendment and criminal procedure amendment, but if we're having a wish list, we really want to have a deep impact or real impact, then it would also require a rethink of definitions in what we call personal law or family law, in definition of marriage, rights and obligations. And without that, what Justice Malla said, having the law in itself is, while it's a first step, it is an important first step. But then there is a whole host of things that can and should be done. And I mean, I've given you a few examples.
So much, Saroop. And I think this what you've sort of outlined in terms of changes required across substantive law, society, and accessibility of state institutions brings us to our next question for Justice Malla. Justice Malla, you are in a very unique position of someone who has worn the hat, so to speak, of being an activist, a lawyer, and now a judge of the Supreme Court. And it would be great if, from your personal experience, you could talk to us a little bit about advocacy that has to happen following the judgment, following the progressive judgment, and what sort of movements you were part of in that respect in Nepal in order to make the judgment effective.
Okay. I think what helps is research, evidence-based research, and also the voices, because our second case was more powerful than the first case, because in first case it was just a public interest litigation a lawyer had filed. In second case, the victim herself two victims had gone directly to the court. That is second thing. Third is prepare the negative arguments, the argument which, just prepare the list of negative argument, and then you prepare a counter argument for advocacy. Fourth is a legal argument, constitutional argument, human rights argument, how you see marital rape is a violation of human right, it's a violation of constitutional right, it's a violation of women's right. So you really have to prepare those arguments. Fifth is collaboration, because you may be a organization working for pro bono, you have certain limitation because you may be doing public interest litigation, but who will take over after that? Because in our experience, even if you have won the case, for example, in equal right for inheritance for daughter, we won the case in 1954, but the law was changed in 2000. Law was changed in 2002. So you see how many years it can take place. So it's not that once you won the case, your work is over. No, it's not that. So it has to be a continuous and collaborative, and maybe you have a limitation, but you have to look for other stakeholders who can continuously engage. And even when you do the PIL, sometimes collective and collaborative PIL is quite useful. Even if you have a victim, but you should be backing up by NGOs, organizations, and different organizations. And sixth is partnership with organizations who are providing counseling, psychological counseling, partnership with who can provide medical aid, partnership with the shelter, partnering with other support system is equally important. And then the strategy is like when you work like even for with the parliamentarian, don't attack only. Give the alternate language, because if you are not happy with the language which has been drafted, give the alternate language. Because you have to empower them with the options. Not only criticizing the law, criticizing the policy, but also giving the options. I think these are the things which has come up in my mind. But engage in whatever capacity possible in the reform process until I mean, of course, de jure, but even for the de facto realization.
Thank you so much, Justice Malla. That's such a clear action plan for what's required. And actually, it applies to most social justice legislations across our region. Naomi, you had spoken earlier about the importance of civic spaces in creating change. And that brings us to a question that's very alive for us as an organization as well. What do you think is the role of regional conversations in creating these legal shifts? And do you think that it's a valuable role?
It is extremely valuable, because there is so much to learn from each other. And we have seen whenever there is a High Court decision from Nepal, India, or Pakistan, Bangladesh court also become interested to talk about these things. And also from Bangladesh also, if there is any progressive interpretation of law, other courts are following it. So we have seen that if Indian court would go for an interpretation on marital rape, so far I know that it is pending with the Delhi High Court, and if they come up with a very specific direction that
Sorry, has Naomi frozen for others, or just me? Naomi, I think you're back.
Hello?
Please continue. Yeah, please
So,
continue.
Sorry. So definitely this type of regional conversation and exchange are very important, but also to share lesson learned session and activism and the common things in activism, how we can help each other through case studies, through the interpretation of law, because the one thing we have in common is the inheritance of the common law, and which is legitimizing marital rape in penal court, and also to have almost similar provision in the constitution in terms of gender equality, and also in terms of international obligation we have so much commonality. So in this respect, there are lots of exchange and dialogue could be happen, that what we have learned from our activism, what type of backlash we have, what type of possible resistance we may have from the formal and informal institution, and how we could overcome it, how we could actually introduce, education on sexuality and reproductive rights, how we could actually interpret the law in a more progressive way. Civic space is very important, and we should use it, or I would use the word utilize it, to learn from each other. So definitely widening civic space where voices from different regions could exchange each other, exchange their views, and then have a common platform and share a same conceptual framework on the basis of intersectionality. That would be great as well.
Thanks so much, Naomi. Justice Malla, we have a general question that relates to domestic violence laws across the region, actually. And a big criticism there has been that with the DV laws, there's been an increase in false cases to settle domestic disputes, etc. And I wanted to understand whether that's something that you encountered in Nepal, and what the responses had been to that argument.
I mean, see, even with the rape cases, people make assumptions that many of them are false cases, false stories. There can be an exceptions, like, no one can disagree with the exceptions. But in general, I have not seen and come across with the false cases at all. So I think it's also a stereotype mindset and that prejudiceness that exists, and which is quite problematic, because I was dealing with a case of murder, and then in that case police even refused to register the case, because instead of trying to find where the lady is, they said, oh, she must have eloped. So when you start the whole, one hand you have a resistance in registering the case, other hand you start investigation also with the prejudice mindset. How can you get the positive results? So there is a prejudice mindset which exists, and that assumption and that notion is also further creating obstacles even for the victim, and to bring the real cases. Of course, with the enactment of the law, now people have a choice, and they have been using the law. Cases are registered, but still, I mean, if you look at the ratio of cases, number of the cases, I'm not happy with the number of with the justice which has been delivered yet. Many women have not been even been able to use the protective orders properly, because there's a whole gaps, lacks of the protection office, support system, even implementation of the immediate protection orders. So there is a huge gaps, in fact, in the enforcement. But I was even thinking, because even in case of marital rape, no woman will just come and make a false accusation because she is a wife. Even in marital, people said that people may make a false cases. So there's whole prejudice assumption, and I think we need to challenge that. Of course, I mean, there can be an exception. There can be a mindset, criminal mindset with women, because patriarchy also is within women. We cannot deny the fact, but then we have to see what is happening to majority of the women.
Absolutely, and that's so relevant to all our jurisdictions. It's so relevant to I think that all the work that we're collectively trying to do. An enormous thank you, Justice Malla, Saroop, and Naomi, for taking the time for today's discussion and engaging with us in the audience. It's been incredibly interesting for all of us listening in. And we'd like to do something with everything we've learned from you today. So perhaps just a position paper that people can access on these laws, and how society is shifting across our region is something that could come out of this. For everybody who joined us in the audience, thank you very much for your time. Thank you for joining us. I realize that many of you are students, so it was very nice to have you with us today. We had over 100 registrations, and we'll be sharing this recording with everybody who had registered but was unable to make it. And again, to our speakers, thank you very, very much for making the time to be with us today. We're about to close out, so if anyone would like to share any final words, please come in. Else we'll close in the next minute or two.
Thank you.
Thank you.
Thank you.
Just a big thank you. Thank you to everybody.
Thank you.
And Sapana ji, best of luck with the work that you're doing in Nepal right now. We're thinking of you tomorrow.
Thanks.
Fully. Thank you very much.
Thank you. Bye-bye.